Can a plaintiff appeal to the Court of Appeals complaining that the Appellate Division denied him summary judgment? To find out, you have to read Bonczar versus American Multicinema, but it's 4 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, Court of Appeals cases in 5 minutes or less. This is the episode on the case of Bonczar versus American Multicinema. It's published by the Court of Appeals on April 28th, 2022, and the citation here is 2022 New York Slip Opinion 02835. A copy of the decision is linked in the description as well as a copy of the oral argument. The issue in this case is the appealability of a summary judgment denial on a claim for Labor Law 240. I'll explain all that in a second. To understand this case, you have to understand 3 kind of concepts. The first is Labor Law 240. Labor Law 240 is a statute that holds liable construction employers, the construction company, for injuries and accidents that are approximately caused by their failure to provide ladders or scaffolds or things that prevent an employer, a construction worker, from falling down and getting hurt from gravity-related fall incidents. That's Labor Law 240. CPLR 3212 is summary judgment. And a summary judgment application, either side can make it. And essentially what it is that I should win, I should prevail as a matter of law. Don't let this go to a jury. I should win as a matter of law. And basically it's a burden shifting test where the plaintiff has an obligation, if they want to make this motion, to demonstrate that they're entitled to judgment as a matter of law. And if they satisfy that, then the burden shifts to the other side to show that there's a tribal issue of fact. Okay. And the last part is CPLR 5501A, which talks about what kinds of things can be appealed. And the statute CPLR 5501A allows an Appellate Division decision to be appealed when it necessarily affects, that's the words it use, when it necessarily affects the final judgment. So a non-final order from the Appellate Division can be appealed when it necessarily affects the final judgment. And one version of the question you can ask to decide whether it necessarily affects it is, would reversing this Appellate Division decision inescapably have led to vacatur of the judgment? If so, then it can be appealed. If not, then it can't. So what are the facts here? The facts are the plaintiff is a construction worker. He's working on rehabilitating or rehabbing a movie theater, and he takes an A-frame ladder and he's going up and down several times to do some work, to fix the fire alarm system. And one of the times he comes down, he falls down and he sues under Labor Law 240. The lawyer makes a motion for summary judgment after depositions are done, for summary judgment, saying we are entitled to relief. We're entitled for you to say as a matter of law, don't let it go to a jury. As a matter of law, the construction company is liable for this incident. The trial judge agrees, grants a summary judgment, but the defense appeals and it goes to the Appellate Division and they issue an order, a non-final order, saying, no, this should go to a jury. There's a question of fact here, has to be resolved by a jury. It goes to a jury, the jury finally hears all the evidence, and at trial, the jury delivers a verdict, not for the plaintiff, but for the defense, for the construction worker employer. So then the plaintiff now appeals to the Court of Appeals and says the Appellate Division was wrong. They shouldn't have done that. They shouldn't have denied my summary judgment motion. I was right. I was entitled to judgment as a matter of law, even though the jury ultimately held against me when they had the whole trial. So it goes to the Court of Appeals and they don't even address the merits of a summary judgment motion. They don't address the merits of the facts or the evidence. This head fake I was talking about is they go to CPLR 5501A and they say this is not a proper appeal. The Appellate Division's order, non-final order, sending it for trial, did not remove from consideration any issue. In fact, it just gave the issue to the jury. If they had removed an issue, like if the Appellate Division had granted summary judgment, that could be appealed because it removes an issue from the jury. But here, they basically sent it to the jury for adjudication, and the jury found in favor of the defense. So the question, would reversal inescapably have led to vacatur of the judgment? The answer is no, not inescapably. There was still a trial of liability and trial of proximate cause and a trial of damages. So that's the case of Bonczar versus American Multicinema. Too long didn't read, 5 minutes or less. Basically, the lesson here is if an Appellate Division denies summary judgment and give it to the trial court, it's very difficult to appeal. If they grant summary judgment and they remove it from consideration, it is appealable. Too long didn't read 5 minutes or less. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.